Filippo, ready where you are.
Right, and this is just an announcement, public announcement. We are recording this. Do what you want. So it gives me big pleasure to be here with Giuseppe and the Jean Monnet Chair Apex to welcome Silvia Nuzzo, Digitrade European Commission and author of the volume Technical Barriers to Trade, Preferential Integration and the Law of the WTO. But not just her, and this is the book. Show the book, Giuseppe.
Here we go.
Very
beautiful
good.
Cover.
It's true.
Terrific cover.
It's true. Out of the press, but we are happy to have with us Charles Cantore, Carlo Cantore, international trade lawyer and adjunct professor at the University of Neuchâtel, and Petros Mavroidis, Pietro Mavroidis, at University of Columbia. The format is as simple as that. We will have Silvia presenting her book and her main findings for 25-30 minutes, and then we'll give the floor to the discussants who will, discuss. There will be maybe a chance for a flying response by Silvia to the discussant comments, but then we will open the floor to everybody. And if that's clear enough, I will invite Silvia to take the floor, and I believe there's a presentation that goes with the speech.
Thanks a lot, Filippo. Thanks for the introduction. I will start by trying to share again my screen, and then I'll start. There you go. Okay. Can you confirm that you see my screen?
Not yet.
Okay,
yes, we do.
Thanks a lot. Okay. Okay, so thanks a lot for being here, and thanks first of all to Giuseppe for organizing this. I was a student in the Scuola Superiore Sant'Anna. I attended many STAS seminars when I was younger, so being a speaker in one of these is like life goals, so I'm very happy to be here. And then thanks to Filippo for chairing the event, and also of course to Petros and Carlo, who accepted to be discussants for this. And I mean, they've provided me with comments on this book for a few times already, but so I appreciate them being here even more. And thanks for everybody who is connecting. I saw a couple of colleagues, and well, they were the ones that negotiated the agreements that I studied. So if you feel like intervening at some point or chipping in, I think that would be really valued. So I'll say a few words about myself. Right now, I am working at the European Commission. I work in Digitrade, and I work on technical barriers to trade. So I negotiate and implement the agreements and the chapters on TBTs specifically. So my PhD has never left me. It's been with me for the past almost 10 years. I don't know how long this is gonna last, but okay. And before that, I was a PhD student at the University of Neuchâtel with Petros. And Carlo was also one of my mentors at the WTO. And before that, I was a student of Giuseppe in Scuola Superiore Sant'Anna. So the title of the presentation is the same as my book, which came out in November last year. And the purpose of my presentation is really to give you reasons to perhaps read it, make you like spark some interest in the topic, and guide you through the structure of the book and the content. I will try to be brief and not too technical, but if there are things that catch your interest throughout the presentation and maybe I don't touch upon for too long, please just raise it and maybe we can discuss in the question and answer section. So I will start by spelling out the research question, few definitions, then I will give you some background information to understand why I found these questions like worth answering, why I consider them relevant. Then I will explain how I went from the questions to the answers, so the methods of the research. I will discuss with you the results, the implications, and some ideas on how to what to get out of this research, like what we can do in practice once we have a look at the findings of my work. So we can start from the research question, which is already enshrined, I'll say, in the title of the book. The book is an inquiry on how preferential trade agreements regulate technical barriers to trade. As simple as that. This is the first question, let's say, is more like descriptive, but then the more analytical part comes after with the let's say the second nuance of the question, which is whether the way that preferential trade agreements regulate TBTs overlaps or diverges from the WTO discipline that applies to technical barriers to trade. And then I ask myself why and what to do about it. As a refresher, to be sure that everybody's on the same page, I added a few definitions of the basic concepts. So preferential trade agreements are international agreements between two or more countries in which the parties decide to grant each other more favorable trade conditions than what they would apply to the rest of the WTO membership or the rest of the world. And then technical barriers to trade are all those measures that are of non-tariff nature and apply, let's say, beyond the border, so to both domestic and imported products, that regulate the way products should be made, labeled, tested, or certified. So to make an example, let's take a product like fertilizers. Technical regulation would regulate the composition of fertilizers that fertilizers need to have to be allowed on the European market, for example. So they are all those measures that regulate the technical characteristics of products and the way that regulating states, then will certify that those standards are met. Technical barriers to trade can be very trade restrictive and therefore have been regulated at the multilateral level since the inception of the WTO, so since 1995, when the WTO-TBT agreement entered into force. The reasons why I think that it is important to look into the regulation of TBTs at the bilateral level is because well, you see already from the definition of the basic concepts that there are two levels of regulation. There is the bilateral one and the multilateral one. Therefore, there could be clashes between the two disciplines. But not only this, what is important is that data shows that preferential trade agreements have become very, very numerous in the past decades. You can see here some data. This comes from the WTO Secretariat. And right now, there are 380 plus agreements in force. And most of them regulate TBTs. Again, data from the WTO. You can see that here, TBTs are basically the regulatory area that is mostly regulated by PTAs. So more than 80% of the PTAs that are in force right now regulate TBTs. TBTs come right after the provisions that serve the basic functioning of a trade agreements, for example, rules of origin or dispute settlement. So TBTs are extremely important because of the trade restrictive potential. And this is why we spend a lot of time and resources in negotiating TBT chapters that actually work in the interest of the parties of the agreements. And then another reason to focus on bilateral regulation of trade is the crisis of multilateralism. I don't think I have to go into it to explain what I mean. I think we're all quite familiar. We've been witnessing the crisis of multilateralism recently, but specifically when it comes to the WTO, we know that the appellate body hasn't been functioning in recent years, that the organization hasn't delivered substantive results when it comes to negotiating new agreements. Therefore, preferential trade agreements are becoming the setting in which new rules for trade have been negotiated. So to check how TBTs are now regulated outside of the WTO, I have come up with a method that is, let's say, threefold. First of all, I have selected a sample of agreements. I haven't read all 300 plus agreements. Then I have developed a template of questions to analyze specific aspects of the text of the agreement. And then based on what I found in the text of the agreement, I have developed a legal analysis to check the compatibility between what I found and the WTO legal framework. The sample of agreements includes more than 80 agreements, and I have included, I mean, all types is a bit an overstatement, but several types, most types of the more important types of agreements that you can find. Free trade agreements, customs unions, and especially mutual recognition agreements, which is previous mapping exercises, those conducted, for example, by the World Bank, that were the most influential probably on the topic, did not take those type of agreements into account. So I think this is one of the most important feature of the book, having a closer look at MRAs. Then I decided to put a cutoff date of the 31st December of 2021, and I divided the sample in 4 subgroups: those negotiated by the EU, those negotiated by the US, by China, and by developing countries only. This gives me a little bit the possibility to compare negotiating strategies and also to control how the regulation of TBTs changes according to the developing level of the parties, development level of the parties that sign the agreement. Then once I got my 80 plus agreements, I read the text and I tried to answer to all these questions. Now, this is a bit overwhelming. Sorry for all this stuff written here. It's just to give you a flavor of the methods that I applied. Let's say that the structure of the template is divided in 3 sections. The first, the ones that deal with harmonization, then mutual recognition, transparency, TBTX. Let's not talk about it. It didn't lead to many findings, so not really relevant. And then control, let's say, variable dispute settlement, to understand the level of commitment of the parties to the obligations that were found in the agreements. A few words on what these things are. So harmonization, mutual recognition, and transparency are the regulatory cooperation strategies that are already included in the WTO TBT agreement. They are all those actions or policies that 2 countries can put in place to decrease the level of technical barriers between them. So to further integrate their economies and to make trade smoother when it comes to technical barriers. Let's take one example, because otherwise everything gets a bit too much. Let's take mutual recognition, for example. Let's say that mutual recognition, first of all, features in the TBT agreement, as said, and it is encouraged. So every time that in an FTA or a PTA in general, we find that mutual recognition becomes an obligation, then we have what we can classify as a TBT plus commitment. So a commitment on TBTs that goes beyond the WTO legal framework. Why is mutual recognition important? So let's say that I am a producer of vacuum cleaners in Basilicata, and I want to export my vacuum cleaners to the US. So if there is no mutual recognition agreement between the EU and the US, I have, me as a producer of vacuum cleaners, I have to ship my products to the US, get the products certified there, and only if I get the document from the competent US laboratory and competent authority, then I can actually put my product into the US, onto the US market. But there is a risk, for example, that once I ship the products, the US authority will find my products are not compliant and I will have to ship them back. Then maybe I don't speak English very well, so there is a language barrier. Then maybe I get the wrong address, or I can't find a competent laboratory. So there are all a set of risks and costs that are associated to conformity assessment. But all these risks and costs can be decreased if I can simply do my conformity assessment in the EU, for example, in Basilicata itself. I go to somewhere down the road, I get my vacuum cleaner tested for the US market, and then I can ship it as it is with the certificate released in Basilicata in the EU to the US, and be sure that my product will be admitted on the market. So this is mutual recognition. This is why it simplifies a lot the life of producers and decreases technical barriers to trade. Now, you understand, however, that this regulatory cooperation instrument can work in two ways. One could be that of boosting only the trade between the parties, so let's say the EU and the US. This is the case if the agreement, the benefits of the agreement, apply only to products that originate within the parties, so either in the EU or in the US. So if the agreement, the mutual recognition agreement, is crafted so to apply only to originating products. And all the third parties will be left at a disadvantage because they will not be able to benefit from the agreement. In contrast, if the mutual recognition exists and does not have origin clauses, so apply to products regardless of their origin, it will benefit not only the parties, but everybody else. So also products that originate outside. Which means that, for example, if I import a lot from China, I will be able still to test the product imported from China and then ship it to the US without additional costs. So indirectly, also Chinese producers will have benefits from the recognition agreement. So all these excursus to explain the rationale of the research. So looking for ways to simplify trade, but also looking at ways in which the parties divert trade, possibly, or boost trade also with their parties. So multilateralize the benefits of their deeper economic integration. The way then the template functions is very simple. 0 if the answer to the question is in the negative, 1 if the answer to the question is positive. I consider only binding language and I look only at the text of the agreement, so I don't look at implementation. Once I have mapped these practices and their potential diverting effects, trade diverting effects, I check whether they are compatible with the TBT agreement, which is why my book features like 50+ pages of super long discussion on how to interpret the TBT agreement, whether the appellate body was right or they were wrong or what they said, so that like all that information is relevant for the legal analysis. And the legal analysis is important because, at least in my view, there is no exception in the TBT agreement or in the GATT that can justify violations to the TBT agreement that occur under the umbrella of a free trade agreement. So Article 24, which is the regional exception in the GATT system, does not apply, in my view, to the TBT agreement. The results are organized in the book according to the three regulatory areas that I looked into, so harmonization, recognition, and transparency, and they are organized first as a description of the data, then the legal analysis, and then I look into how members reacted to these practices that may have this trade distortive or trade enhancing effects. The reactions of the members are those that were, let's say, submitted through formal channels. So, for example, disputes or in the TBT committee or in other WTO committees that dealt with the trade agreements. Let's, in the interest of time, we can, I mean, there are, of course, data for all the three things, but let's look, for example, at those that concern recognition, so the mutual recognition agreements that we talked about earlier. What I found, for example, is that there are 30 agreements that include recognition obligations. This is more or less 40% of the sample. So there are, in 40% of the agreements surveyed, the parties go beyond the WTO and decide to integrate further. Mostly these are, for example, parties with a high level of development, that have a high level of trust between each other, that conformity assessment, for example, will be performed in one or the other country in a sufficiently trustworthy way, let's say. But out of these 30 agreements, in 10 agreements, there are restrictive origin clauses. So 10 of these agreements potentially divert trade with third parties instead of multilateralizing the benefits. So I check whether this can be justified in the TBT agreement. And of course, the answer, as always, is it depends. It depends on the product, but mostly depends on the risk. The risk that recognizing conformity assessment performed in a third country will pose to the consumers ultimately. So the higher is the risk of products non-compliance, and the higher is the risk that is associated to just accepting conformity assessment performed elsewhere, the higher are the chances that restrictive origin clauses are legitimate under WTO law. Yeah. Despite all these doubts about compatibility and the possibility of trade diversion, etc., I have recorded no reaction in WTO membership to this specific issue. So even if there is a violation, nobody seems to care. And then I ask myself why. Of course, it's a matter of private information, but then I put forward some hypotheses. For example, that the markets are too small, or that countries, WTO members that are most active, are not really interested in certain products, etc., etc. So it's a long discussion on that side. Same for transparency. I mean, if this, I lost the track of time, but I would, in case this is of interest, we can go back to this later in the question and answer. Anyways, so to summarize the findings and understanding what all these data collected and all this analysis means. In my view, what we observe, if we look at preferential trade agreements and the way they regulate TBTs, what emerges is mostly that countries do not diverge too much from the multilateral discipline, which means that the TBT agreement is still perceived as largely adequate to regulate transactions also at the bilateral level. So even if it was adopted 30 years ago, even if now multilateralism doesn't seem to work anymore, the principles that were enshrined in the TBT agreement are still good enough to regulate trade at the bilateral level. The let's say the innovations on the multilateral discipline are either strengthen the multilateral obligations as they are, or if they deviate from them, it's not because of mere protectionism, at least not prima facie, but it's more, those deviations are more, seems to be more due to the types of products that are concerned by the restrictions or the broader relations between the parties. For example, if the EU is negotiating with a country that is candidate to accession, it will require, for example, harmonization to the EU standards, because it's part of the process of becoming a EU member, instead of requiring harmonization to international standards. So this will be the reasons behind the deviation from the international obligations are going to be like due to something different from protectionism, different from the will of creating a bloc and diverting trade coming from third parties. And then at the same time, the WTO and the TBT agreement remain good enough to ensure that any of these potential deviation does not affect too much third parties. So let's say it's as if now most of trade is going to be regulated in free trade agreements. The WTO, it's not the center anymore, but still can have a role by ensuring that free trade agreements free trade agreements make more good than harm, let's say. Free trade agreements can work in the best way for the parties, also for third parties, and reduce the damage, let's say, that can stem from preferential integration or the preferential integration. And then in this slide, I come up with some proposals to strengthen this synergy between preferential trade agreements and the WTO. So, and what I think the role of the WTO could be is that of increasing transparency, increasing the participation, for example, of private person in the dialogue between members in the concerned TBTs, facilitating, let's say, discussions that can lead to plurilateral initiatives to, let's say, multilateralize lessons learned from PTAs, or gathering and disseminating more information on the way that trade agreements are implemented and how they actually work, so that they can benefit a larger set of stakeholders. So this is the takeaways of my research, yeah. So yeah, this is my conclusion. This is I hope that it gave you some info and some food for thought, also for other regulatory areas that maybe can be addressed, can be analyzed, and then innovated like this. So thank you very much.
Thank you very much, Silvia. And that was really fascinating and bang on time. Now,
Okay,
so discussants are also very diligent. And I believe that the best way to start is with Petros Mavroidis. And I will give him the floor for maximum 15 minutes for comments before we call Carlo to weigh in.
Okay, thank you very much, Professor Fontanelli. I'll take 10 minutes so Charles can have more time since we speak in English. I want to make essentially two comments and I explain. First, I want to explain why this work matters. It's not the time. I spoke with Silvia, as you can imagine, for 4 years, thousands of times about the thesis. And second, what has been changing since April 2nd, 2025? And then I will prepare the floor, if you wish, for Charles. Now, why it matters? I think there are three reasons why it matters. First, TBT is along with SPS, the best anti-protectionism test we have in the WTO. I spent the first 2 months of the year at Stanford was participating in a forum with 3 constitutional lawyers and Alan Sykes. And quite frankly, what emerged from those discussions was a weekly forum, was that even in constitutional theory in the US, where they spent hours discussing discrimination, years, weeks, and months, they have nothing like a test comparable to what we have in TBT-SPS. So the moment you understand how TBT-SPS works, I'm not saying the test has been coherently implemented by panels, not at all. But the test as such is quite the closest we can get to, the closest proxy to defining an almost undefinable term protection. And this is one very important reason why TBT matters. The second is the TBTs, let's say, pre-April 2nd, 2025, were the main market segmenting factor. So this is an agreement dealing with, if you wish, the key barriers to trade around the world. Michele Ruta at the IMF now, but also before at the bank, had a series of papers discussing importance of market segmenting factors. Now this work has been taken over by Global Trade Alert consistently until April 2025, non-tariff barriers in the form of production process PPMs, irrespective whether they are embedded or not embedded in the final good, come up as top of the list. And the third reason is why it matters is because this is an area where like-mindedness matters a lot, and that's one of the points that come out quite strongly in Silvia's work. It is not just mutual recognition agreements, and Silvia had no time to explain everything she did in her book, but in her book, if you read carefully, consistently see that WTO X elements are across like-minded players, not across unlike-minded players. And this makes perfect sense because preferences are endogenous in societies, and the level of development is slightly only vulgarized. Is probably the best explanation for cooperation in this context. I mean, you wouldn't think of Italy discussing conformity assessment of environmental measures with sub-Saharan Africa, but Italy would do it with Denmark or with Sweden, countries which are much closer to the current development of Italy, plus, when I say Italy, I mean, of course, north of Florence and above, not Basilicata or Potenza. You would expect, I mean, like-mindedness to be the key explanatory variable. Now, only for these three reasons, I think the work of Silvia is super important, and it's irrelevant if I happen to agree, but even people who disagree with Silvia's conclusions, it would make perfect sense to read the book only to understand these 3 points, which are, in my view, the heart and the soul of this this work. Quite frankly, I don't belong to the category of people who think writing a thesis along those lines should be full of innovation and stuff like that. An adequate description is, in my view, innovation in and of itself. And Silvia did this part and in the most comprehensive and clear-cut manner. But I hadn't seen this done before. Now, the second thing I wanted to say is what happened after April 2. Of course, this is something Silvia could not have anticipated when doing her work. She was already a doctor in laws. She was working in the European Commission. nobody, I think, had anticipated, no matter what people feared. And even judging by the first Trump administration, nobody could predict Liberation Day and whatever followed Liberation Day. Now, why is this important? But again, Silvia has a number of responses in her book. Well, it's important because suddenly the most important market segmenting factor became tariffs. If the US was St. Kitts and Nevis, we wouldn't be talking about it, because who cares if St. Kitts and Nevis increase their tariffs by 900%? But when the US does, there are trade effects. And that was point one. Now, point two, when tariffs become so important, of course, the last thing you care about is non-tariff barriers. That goes back to Baldwin 1969. I mean, you cannot even appreciate non-tariff barriers when tariffs are high. So what we observe nowadays, and this again comes very much out of especially the work of the Peterson Institute in the last year, now it's the second year in a row, is that non-tariff barriers, while the US does everything you can imagine and more, unfortunately, Europe also is following to some extent, because Europe buys into the argument of conditionality of MFN. I'm totally opposed, but who cares about our opinions? And now I see a tendency, for now only in the US, not in Europe so far, even in the realm of TBT, to do discriminatory interventions. And not only do it inside the US, but do it also in agreements they sign with the rest of the world. I had to read the Malaysia-US agreement. Quite frankly, it is an abomination. And you read this agreement and you say, my God, I read Silvia Nuzzo, I get all those ideas, there is no exception to TBT, blah, blah. And then I look at what is happening, what's going on, which brings into, I think, perspective another part of Silvia's thesis, the question of the forum of enforcement. Well, if there is one thing that still works a little bit in the WTO is the specific trade concerns. So this type of issues, I would imagine, will find refuge in the realm of STCs. So for the purposes of this discussion, I called Lauro Locks, who Silvia knows very well, who is one of the people who drive the TBT discussions in the WTO. So far, everybody is holding, let's say, the guns close to itself. There is no much activity. But I suppose this is, let's say, some sort of truce, but no peace. Eventually, people will come out, because the measures that the US is putting in place go directly against some of the most important trade interests of especially the European Union and China. I don't know for how long they will hold fire. I assume the big players in Europe, Germany, France, Greece, they will start reacting to this reality. And I will stop here. Thank you very much, Silvia, for the work. And it was, I have to say it in public, a great pleasure to work with you, especially after experiences I had with other Italian students who wrote their thesis with me. Thank you.
And on that note, I call to the floor Carlo Cantore, international trade lawyer and adjunct professor at the Université de Neuchâtel.
And friend of the STALS project since day one. So that's how I would like to be introduced, actually. No, thank you so much for the invitation. It's good to be home, although virtually. And I find this seminar particularly important because I think, to my knowledge, it's the first time in history that a webinar on international trade law features a relative majority of speakers from Basilicata. I think, this is a stream of scholarship that has been long neglected, and I think Giuseppe is doing the right thing by, changing course. So I would take a Basilicata approach to international trade and try to okay, yeah, Filippo, the chair is not impressed. No, thank you so much. As Silvia said, I had the privilege of engaging with Silvia's work early on, but I think let me say something. I think I would focus my intervention on two things. I would give some praise to the book and highlight why I think this is an important addition to the literature. And then I will actually ask some questions to Silvia, because I think she and I fully agree with Petros. I mean, her contribution is very important, if only because she provides us with a clear picture of the existence, but she also made proposals for reform. And I think on that note, I think I would like to hear more from her, especially in light of recent events and the failed ministerial conference of 2 weeks ago, last week. I think it is a much needed book, and it's a book that complements existing literature. And at a time where the WTO's negotiating function is practically paralyzed, and members are intensifying discussions at the preferential level, we need to know what's going on, and Silvia Nuzzo tells us what's going on. I was an early fan of her work. I served as an external rapporteur for her defense, and we talked about these issues many times. And what I really appreciated was her stubbornness on certain ideas that she acquired early on, she had early on, and she defended throughout her thesis. And this is what you expect from a PhD endeavor, to develop a thesis that can be defended, and she can defend her argument irrespective of whether you agree or disagree with her. I personally agree with most of her claims, but that's besides besides today's point. I think Silvia has kind of made it simple, making her introduction to the book and describing the nature of her book. But I think there are a few aspects that need to be highlighted to show the importance, to help us appreciate the importance of her work. First of all, she could not rely on consolidated existing literature in the legal field on these topics. And like echoing Petros's point before, so apart from some policy reports from international organizations, detailed contributions in some sectors, some industrial sectors, and some discussion in economic literature, she could not benefit from an analysis that was already conducted by others in the epistemic community. So she did not start her work by criticizing the work of others or by building on the work of others. And I think the book shows an excellent, an impressive degree of maturity, because Silvia borrows from economic literature. She establishes a dialogue with scholars from other disciplines, which makes for a rich picture. And not only this, but she combines doctrinal work with hands-on practical approach. When she didn't have an answer, she didn't hesitate to interview delegates, to talk to experts, to fill information gaps. And this transpires from the book. So this book will be interesting for scholars and practitioners alike. What Silvia does in this book is she combines an overview of TBT provisions in PTAs without overlooking economic considerations and implication. The example she was making before is but one example of the things that she discusses in her book. And I think this is something very, very interesting and valuable. And I think this is something that this is a book that should be shown to young scholars who are approaching the PhD endeavor. Also, Silvia had to select a subset of agreements to look at, and there was a serious risk of sample bias. And what she did here was very interesting, because obviously she focused on the main hubs, the EU, US, China, to see how the three interact with the spokes. Clearly, these are the three main trade players, and whoever wants to know what's happening in international trade policy needs to work on that basis. But in addition, she also highlights some differences, some nuances. She looks, for instance, at what the EU does in the context of the EU integration process, which I think is particularly important in light of the sui generis nature of the EU. And the addition of South-South agreements in the analysis is also interesting, because she added a needed development angle to the analysis of trade policies, and something that is that is still catching up, whereas in other fields of international law, we're seeing these more prominently. In international trade law, we are in the early stages of this, and I think Silvia does a very, very good job in that regard. And I think it is also important to expand the scope of observation to mutual recognition agreements, because they are somehow neglected when discussing preferential integration. Most scholars, they focus on preferential trade agreements, FTAs, but what's happening in mutual recognition agreements embedded in free trade agreements or negotiated outside of FTAs is particularly important, and she nicely maps out the various provisions in the WTO agreements or mutual recognition agreements, pulling some strings from early pioneering work on mutual recognition agreements and in other fields. And I think that is a particularly important aspect of her working on her thesis. And finally, I think another quality of this book is that Silvia addresses thorny issues of legal interpretation, both in the context of evaluating the state of play of WTO case law on the TBT agreement, as well as when she addresses controversial questions, such as the question in the book as to whether Article 24 of the GATT can be invoked to justify preferential treatment in the field of technical barriers to trade. And in this respect, I think she does a great job, and that's where I'm saying that's why I say she has a thesis and she puts it forward. She defends it convincingly. I mean, we can agree or disagree, but she has a thesis that she defends throughout, and she supports it with solid argumentation. So I think that anyone who will need to write about technical barriers to trade and international trade policy will have to engage with her work, and I think this is what one would aim for and would hope for. I mean, when rolling up one sleeve and trying to write a PhD thesis. Now, enough said, and as you may have understood, I'm a huge fan of this work, so I'm very happy to sit on this panel. I have three questions for Silvia, because, like I said, another important contribution that she makes is as she puts forward options for reform, even though the climate is not ideal, one hopes that this situation will eventually improve so that there will be time for adults in the room to sit down and discuss meaningful ways to return to a more cooperative mood on the international trade field, where meaningful conversations on negotiations can continue and progress. So Dr. Nuzzo argues that plurilateral initiatives could be crucial for the survival of the WTO. Now, without opening a big Pandora's box, but the state of plurilateral initiatives at the WTO is not ideal, in the sense that there are currently two plurilateral initiatives that are stuck, that cannot proceed with integration into Annex 4 of the WTO agreement, because to do that you will need consensus, and there are naysayers who block the adoption of a decision at the Ministerial Conference or the General Council by consensus. So recently we've seen movement on the e-commerce front, where a subset of members of the WTO have decided to go ahead and begin with the provisional application of the agreement without waiting for a decision to integrate the agreement at the WTO. In her book, Silvia tries a different angle, and she suggests scheduling as an alternative, in my view, more kosher from a WTO law point of view. So I would like to hear more on this from Silvia, because I think the discussion could benefit. And I wanted to ask Silvia whether she thinks that would be preferable compared to the solution envisaged by some of the participants to the e-commerce plurilateral, because I think that poses questions under WTO law and under international treaty law. The second question I have is about the recently circulated proposal by the US ahead of the WTO ministerial on how to advance discussions at the plurilateral level. And you also suggest possible reforms of the rules for the integration of plurilateral agreements. What do you think of that proposal? Does it fit well with what you're proposing? And finally, on the policy side of things, recently the EU also, in response to the events of April 2 and the aftermath of April 2, 2025, the EU has announced the conclusion of FTAs with key trading partners, India, Mercosur countries, Australia. Is there anything interesting for your arguments in those agreements? So thank you so much. I hope I stayed within the 15 minutes. If I didn't, I'm sorry.
No, you were bang on time again. And I would like to invite Silvia for first reaction to yours and Petros's comments. And maybe if she wants, also tackle these questions on scheduling, the post Liberation Day scenarios, anything that she wants before we open to the floor.
Thank you, Filippo. Thanks a lot to Petros and Carlo for their words. I think they've been way too kind with my work, and I mean, I will never thank them enough. Not only for the support throughout the work, but also for the way they speak about my work and how much they have engaged in discussing it with me. So that's really appreciated. With Petros, I mean, I cannot but agree with what he says, and I think, I mean, I would not have much to add. Besides maybe one point, it's true that Liberation Day made tariffs the center of trade policy. After years and years of market being fragmented by non-tariffs. But at the same time, I feel that tariffs is just a leverage to then discuss non-tariff measures. And that you can, and then you see in the agreements that the US have signed with some of the countries with which they have engaged. There are tariffs, of course, are the number one, let's say, topic, but then they want to what they want to discuss. It's really non-tariffs. It's really TBT. It's accepting US standards in those countries. So I think that non-tariff measures still bite, even in this post Liberation Day kind of scenario. Carlo, you ask very difficult questions as usual, and honestly, I don't know if I have.
That's what I do.
5% of the answer, which means that probably we're gonna meet up somewhere, have coffee, and maybe go through this more in detail when I will have done my research more properly than today. But I can start by sharing some thoughts that I have. On plurilaterals versus scheduling, I think. I mean, I think a lot depends on exactly what we are looking at. Of course, into schedules you can fit maybe aspects of your trade policy that are not as complex maybe as you could do in a plurilateral. So it depends a little bit on the scale of what we are discussing. When it comes to TBTs, I think scheduling are a very good solution because many of the things that can be improved when it comes to TBTs is really clarity. So it could be useful to add into schedules of concession, for example, some clarification of what is intended as international standards that would help already, or how certain things should be interpreted according to the country, etc., etc. So I think it's a matter of scale. And of course, there is all the discussion on whether additional concessions, whether they come through plurilaterals or schedules, they should be MFN or not. And when it comes to schedules, then of course, then your whatever you concede, it's going to be MFN. Whereas if you do a plurilateral, then you have much more leeway to even if I think ultimately the MFN as a pillar of the GATT would apply nevertheless. So in my view, as a defender of the multilateral system without discrimination stuff, I would be more inclined of seeing into scheduling a policy that a choice that is more in line with WTO principles, but at the same time, it's really a policy choice. So I was positively impressed by the US submission on WTO reform and the way and the relevance that they give to plurilateral initiatives therein. I think that signals still an engagement with the system. Otherwise, they would have simply suggested to disregard any possible engagement under the WTO umbrella and go ahead with that. So I think that's a positive sign. At the same time, I think that what really would make a difference when it comes to plurilaterals is going past consensus. And maybe that's something that the WTO members should discuss if they really want a meaningful engagement on plurilaterals. Probably the idea of requiring all WTO members to agree and to add a plurilateral initiative, a plurilateral agreement to Annex 4 is not necessary, or is what is actually blocking. I see Marie-Pierre. Is what is actually hindering then reform in the WTO or the usage of this kind of agreements. And the US do not mention that, probably because, giving up on consensus would mean giving up on some sort of control that the members have on each other. So it's not an easy choice, but that's probably what would make a difference. And then to conclude, I think, well, there are some colleagues of mine that have actually been in the call, that have negotiated the agreements that you mentioned, especially with one with India. There was a lot of discussion among us on how to negotiate that, what to include and what not to include. I think as far as I know, these three agreements do not depart from the EU usual position when it comes to negotiating TBTs, which is that of incorporating the WTO TBT agreement and build on the existing obligations. So I think that also these new agreements confirm the thesis that I put forward in the book, and will, let's say, also contribute to keeping the TBT agreement and the WTO legal framework relevant, even if through a different avenue, which is that of a PTA. Voila. So I hope I replied at least partially to your questions, and I'm happy to talk about this more in coming days or whatever we have the chance.
Wonderful, wonderful. And let me know if you have questions. And Giuseppe, please help me, because I might lose sight of who's booking for a question. But while people are probably going to raise their hands, let me clarify a point that is probably a minor one. So you said that TBT restrictions should not be justified by Article 24. Does that mean the old bilateral mutual recognition agreement are illegal? Sorry, what have I missed there?
They are not illegal, but there is a way, let's say, there is a specific way in which the TBT agreement regulates preferential integration, and that is that of encouraging the parties to the agreement to consider applications from third parties that are interested into joining the agreement. And if that happens, the parties under a TBT agreement have an obligation to engage into discussions. And then if they do not want to extend the benefits of the MRA to the third party that is asking for it, they will have to justify it. As far as I know, this has never happened. So the MRA itself is not illegal. That's perfectly legal. It's actually encouraged by the TBT agreement. But the way in which you can exclude third parties from the benefits of the agreement is different than in the GATT. Because in the GATT, you can do it as long as your agreement is GATT compatible, right? Is compatible with Article 24, liberalizes substantial trade, etc., etc., etc. In the TBT agreement, I think the mechanism works differently, and that's what I explained. I hope it's clear.
Right, but in the practice, most MRAs do not have that open to third parties in the practice, so they are illegal.
I wouldn't say that. I wouldn't say that they are illegal because they are. It's not written in the agreement that it's not open. If you what is written in the TBT agreement is that an MRA is, let's say, the parties of an MRA can conclude an agreement as such, but in case a third party asks to be included, they have to engage meaningfully with the third party and decide whether that application is acceptable or not. You see what it's a bit different. And if it's not, they have to justify it. So it would be
wonderful
the way that the parties justify that exclusion. That could be TBT incompatible or not, but that's never happened.
Okay, I stand corrected, and I collect questions now. Who wants to come forward?
Work. Hi, Katia. Nice to meet you. I used to work in the area of TBT for quite a long time. So I would like to, first of all, thank Silvia for doing this work, which I think it's a seminal work on TBT that has been done so far. So it's really something that that has never been done, and the way she has approached the matter, it's very systematic. So thank you for that. And I would just have a follow-up question on what Filippo was saying on about the MRAs, and to what extent the origin clause or the lack of the origin clause is running against the provisions of the GATT. Thank you.
I also have a question. I don't know if Filippo. Okay, so I'm gonna give myself, let's say, the power to raise a couple of questions. I know that. Thanks so much, I mean, Silvia, for presenting this fantastic book. I must say that when we have received the copy of the book, we immediately wanted to have the book launch, I mean, like this. So it's indeed our pleasure and honor. Thanks so much also to the discussants and friends that have enriched this webinar. I know that today you are speaking in your capacity as a scholar, but I would like to raise a couple of questions to say, looking at the perspective of the European Commission. So from the perspective of the Commission, what is the biggest, I would say, practical challenge that that we may find in trying to ensure and trying to guarantee that our trading partners actually implement the TBT commitments outlined in this very complex preferential agreements? And this the first question. And the second question is, how does the EU reconcile its sometimes ambitious domestic legal claims? I mean, think of the Green Deal or the Digital Act, for instance, with the TBT chapters in its PATs in order to avoid being, let's say, accused of creating unnecessary obstacles to trade. We know that in these periods, regulation is under siege in a way, and that there are different sources, I mean, from Mario Draghi, I mean, to Donald Trump, I mean, that have accused the European Union of creating unnecessary obstacles to trade. So how can we respond, let's say, to this arguments? Thanks so much.
I will now give the chance to Silvia to answer to Katia's and to Giuseppe's comment, and invite everybody else to come up with further questions.
Thank you. Thanks a lot for the questions. To Katia, on origin clauses, I think a lot depends on the products that are at stake in the MRA, and whether the parties can prove that performing the conformity assessment in the third country, let's say, that does not benefit from the MRA, would increase the risk of non-compliance, or actually pose a risk of non-compliance. So, for example, if you take organic products, that were some of the products that it was one of the sectors that emerged as regulated by means of an MRA with restrictive origin clauses. There, the way in which the product itself is manufactured in the country is also relevant for to then obtain the organic certification. And there are aspects of organic products that you cannot prove when you perform conformity assessment, because they are inherent to the production process, but they may not have a physical trace in the final product. So if you perform conformity assessment on an organic product without checking how, I don't know, the water is used in the country of origin, you cannot actually define that product as organic. So in this case, you have no choice but closing the MRA to third countries. But when it comes to different products, maybe industrial products, and when the conformity assessment that you perform in Europe would be exactly the same that you would perform in I don't know, Argentina, because all the characteristic of the product would be inherent in the product itself. It could be checked by means of conformity assessment wherever the conformity assessment is done. Then you have a problem, in my view. Then it's more difficult to justify closing up the MRA. I hope it makes sense. Yeah. And in this case, I mean, what you can argue is, for example, that you don't trust this third country because they have, I can just make examples. They have a high level of corruption, or they don't have a good track record when it comes to product compliance with standards in a specific sector. So you would have probably not to look at the product itself and the risks that are posed in the product itself, but more at the broader picture to justify a restrictive origin clause under the TBT agreement, and probably it's going to be the necessity obligation that comes into play. So this would be my first reply. Giuseppe, your first question was about implementation of FTAs, how the Commission implements them.
My question was about the biggest challenges that they can find when when dealing with the implementation of these PTAs.
I'm thinking. I can give you the TBT perspective, because every policy area has its own specificity, and I'm not an expert of the implementation of the agreements throughout. So I can give you the TBT. In that case, I think that a big challenge is fact finding, for example. Really in our daily lives, understanding how barriers work in third countries, getting the details of the measures, understanding why these measures came to be, whose interests they are, let's say, they are protecting, which stakeholders. And once one does this fact finding, then it is important to understand what instruments actually the agreement gives you, because many of the agreements that we have do not have strong commitments on certain aspects. There is, for example, on conformity assessment, we have the TBT agreement that applies, but we don't have anything more. So when it comes to, for example, simplifying conformity assessment between two countries, you only have the multilateral arsenal, but you cannot come up with different arguments to ask your counterpart to simplify access to their market. So I think those are some of the main challenges, like really understanding the other market, and that we do mostly through our industry that is there on the field that gives us the information, and the way these barriers actually affect their trade, and then trying to find the leverage to remove those barriers. And sometimes you have less than you would think under an FTA at the technical level, and the very, very technical level, which is just me talking with my counterpart in another country that is part to an FTA that has TBT provisions inside. And I mean, on the other regulation, I think we are quite exposed on that. You can see that if you just check the agenda of the usual TBT committee, you would see that is the EU that has most of the defensive cases, because we do indeed regulate a lot. It's part of our, I think, it's the way we do things in Europe. But at the same time, we indeed are exposed to many specific trade concerns. So to many, let's say, many WTO members becoming vocal about the barriers that they face in the EU market. But at the same time, those concerns have rarely escalated to the point of a dispute. So there are problems, but let's say probably it is the reasons why these measures are adopted are legitimate, are probably going to be found to be legitimate under WTO law. Therefore, countries do not often challenge them formally, even if they rightfully express the problems that they face. And one of the most recent cases, I think, was the palm oil case, in which Indonesia challenged a measure adopted by the EU, which was found to be a TBT measure. But in that case, if I remember correctly, the EU was found to be, don't quote me on this because maybe I should revise my case law, but the EU was found to be in compliance with the necessity obligation. So those restrictions on trade that were indeed imposed were imposed for legitimate reasons. So this is a bit the picture that I see.
Well, and we have done with several questions. Thank you very much. I just give the opportunity for last minute question, final comments or doubts from the audience. And if I don't see them, then I would pull this to an end. And thank you very much for this wonderful presentation and discussion. And thanks to Giuseppe, as always. And thanks to the discussant 1 and discussant 2. And once again to you, and congratulations on your book.
Thank you. Thanks so much to everyone.
And thanks to Politano. Ciao.